My Lord, before I resume, if I can just pick up on a couple of loose ends from this morning. First of all, on the context, on the question of the application to leases of the doctrine of frustration and repudiatory breach, the answer is that both apply, but only exceptionally. So far as frustration is concerned, there's an authority called National Carriers and Panalpina from, I think, the 1970s, referred to at paragraph 17.281 of Woodfall, which holds that the doctrine of frustration can apply. So far as the doctrine of repudiatory breach is concerned, I'm reminded that there is in fact a decision of the Privy Council as recently as December last year called Ramsbury Properties and Ocean View, which affirmed, it didn't actually make new law, but it affirmed that a tenant can certainly accept a repudiatory breach by a landlord and bring a lease to a close. Woodfall considers that a landlord could also accept repudiatory breach by a tenant, albeit care would have to be taken not to deny the tenant the usual protections of relief against forfeiture. And I'm not aware of any authority at this juncture in which a landlord has accepted a repudiatory breach. The reference in Woodfall is paragraph 17.314, and as with frustration, the answer seems to be the doctrine applies, but exceptionally. And then just on Lord Justice Lewis's question about remedy and cure, perhaps before I resume my trawl through the authorities, we can look at Schuler again, page 102, where Lord Reed refers to the two different ways of remedying, effectively. This is the bottom of page 102. He says it could mean obviate or nullify the effect of the breach so that any damage already done is in some way made good, or it could mean cure so that matters are put right for the future. And says, I think that the latter is the more natural meaning. So I think hopefully that supports my answer that they should be treated as synonymous. Before lunch, my Lord, I was about to move on to my next authority, which is the Phoenix Media case. This is page 189 of the authorities bundle. A decision, an unreported decision of Mr. Justice Newberger, as he then was, from May 2000. This was a commercial dispute in which the seller of a business information package was held to be in material breach of a licensing agreement by dealing with what the contract referred to as excluded organisations, so as to justify termination. The helpful paragraphs of the judgment to look at are, first of all, paragraph 1 on page 190, which gives that summary. Essentially, Phoenix were entitled to incorporate into its software product a product made by Cobweb Information.
Sorry, I wasn't keeping up. Which
page 190, my Lord, paragraph 1.
Yeah, I see. Yes.
But Phoenix were given this permission on terms which included a prohibition on dealing with certain excluded organisations, and as we shall see, that's what they went on to do. The early paragraphs of the judgment are concerned with some of the provisions of the contract. If I could ask you to look at paragraph 19 on page 193, the court will see the reference there to clause 7.5, which deals with the prohibition on trading with or supplying so-called excluded organisations. And I should also draw the court's attention to paragraph 21, because one of the points of difference said to arise between this case and our case is the inclusion in the contract of an express obligation of good faith. That's clause 15, which is set out at paragraph 21 at the bottom of page 193. Does the court have that? Going on to the top of page 194. Moving on to paragraph 22 on page 194, we see the termination clause. Similar sort of structure to the ones we've seen in the earlier cases. The period of remedy here, 30 days. Clause 17.3. And then the essential allegation made against Phoenix is set out in paragraph 25. The letter making a complaint, letter referred to there, making a complaint that Phoenix had dealt directly with Daily Mail, Spices, Norweb, etc. And that was said to be a breach of inter alia clause 7.5 of the agreement. And over the page, on page 195, it records that Cobweb purported to determine the agreement with immediate effect. The issues in the case are then set out at paragraph 29. And it's the second issue we're really concerned with here. If PML is in breach, whether Cobweb is entitled to determine the agreement as it purported to do on the 14th of February 2000. And the way in which that was dealt with is then at paragraphs 59 to 61 of the judgment, page 203 of the bundle. And here Mr. Justice Neuberger asks the question rhetorically, given that there are breaches, are they material and irremediable? And he applies that then to the termination clause we've just looked at. I'd ask the court please to read paragraph 60 and 61.
Yeah.
Now, what's interesting about this passage on analysis is obviously it explains the overlap between materiality and irremediability. But in the context of irremediability, what Mr. Justice Neuberger says is that deliberately committed breaches, it will be easier to argue that they irrevocably and negatively impact on what would otherwise be an ongoing business relationship involving trust and confidence between the parties. Now, he then does refer to clause 15. There's no indication on my reading that the decision turns on the presence of clause 15. And we'll see from some of the authorities we look at later that this idea that the way in which a breach is committed can impact on remediability surfaces again in circumstances where no such clause exists. And in my submission, it would be wrong to argue that cases of this kind turn on the inclusion in a contract of an obligation of good faith, which, to be clear, we don't have in this shareholders agreement. Every relationship or the continuation of every relationship depends to some extent on trust, confidence, whatever one wants to call it, whether that's in the commercial setting or other settings. That may be the more pronounced where it's elevated to an express term of the contract. But the mere fact that it doesn't appear in the contract does not mean, we submit, that notions of trust and confidence or the lasting effect of a breach on the other party can simply be dismissed to the status of an irrelevance. And so what we take from Phoenix Media is the proposition that in considering remediability, one is concerned not just with the nature of the breach in terms of its practical effect, but potentially something deeper as well, such as its impact on the longer-term relationship between the parties. I'm going to come back later on, in the context of Ground 7 in particular, to the Swiss Atlantique case, to which reference is made in the judgment, where the House of Lords say that a breach may be treated as a repudiatory breach if deliberately and willfully committed. And just to foreshadow my submission on that, I say that this idea embodied in paragraph 60 of the Phoenix case is consistent with that. One is not just looking at the outward consequences, one is looking at a wider range of considerations, motivation, impact on innocent party, and so on. So that's Phoenix Media. And I don't think there's anything else I can usefully take the court to in that case. And I therefore move on to the next one in time, which is Aichi. This is at page 254 of the authorities bundle, another landlord and tenant case. Now, in this case, there was, in the context of a commercial tenancy, an obligation which we see set out prominently in the headnote, not to charge, assign, underlet, or part with possession of a part of the demised premises, nor to share possession of the whole or any part of the premises, etc. And the complaint made here, which might be thought to be a rather technical one, is that the tenant had taken a tenancy in his capacity as a private individual, but that then traded from the premises as a limited company. And the allegation was that this amounted to a sharing of possession because there were effectively two different legal entities in occupation. In that context, the ability to remedy the breach arose. And that question is addressed by the Court of Appeal at paragraph 62 onwards, at page 266 of the authorities bundle. The question was perhaps particularly tricky on the precise facts of this case because it's been held in a landlord and tenant context that involving third-party rights makes a breach either irremediable or much more difficult to remedy than if third-party rights are not involved. So as we shall see, there's authority referred to in this case that the assignment of a lease, for example, is irremediable because third-party rights have become involved. Now, Lord Justice Neuberger begins by, paragraph 63, considering the matter free from authority. And he says that considering the matter free from authority, I would be firmly of the view that a covenant against sharing possession, indeed a covenant against parting with possession, should be capable of remedy. And he goes on at paragraph 64 to adopt the approach that we've seen adopted in the early authorities. The proper approach to the question of whether or not a breach is capable of remedy should be practical rather than technical. In a sense, it could be said that any breach of covenant is, strictly speaking, incapable of remedy. And he gives the example of a tenant who's required to paint the premises every 5 years and fails to do so. But he says at the conclusion of that paragraph 64 that such arguments are unrealistically technical. He says, I would have thought the great majority of breaches should be capable of remedy in the same way as repairing most user covenant breaches. And even if the lessor is left out of pocket, he says, it doesn't seem to me there's any problem in concluding that the breach is remediable because section 146 provides for the payment of compensation. And then over the page at page 215, he turns to the authorities and he refers to two types of breach of covenant which are, as a matter of principle, incapable of remedy. And the first, he says, is covenant against subletting. And that's, as we see it, letter C, based on the proposition that one cannot, as it were, uncreate an underlease. And then in that context as well, he talks about the general assumption that an unlawful assignment also constitutes an irremediable breach of contract. And then he, at paragraph 68, turns to the other type of breach of covenant incapable of remedy, which is a breach involving illegal or immoral use. He talks there about stigma. And the words that I would particularly draw attention to are those towards the end of paragraph 68. However, in terms of policy, there's force in the view that a lessee who has used premises for an illegal or immoral purpose should not be able to avoid the risk of forfeiture simply by ceasing that use on being given notice of it, particularly as relief from forfeiture would still be available. And he gives another example of a breach of a covenant to insure against damage by fire, where the property burns down before insurance can be effected. Now, what I take from this is that although Lord Justice Neuberger adopts the approach that the approach to remedy should be practical rather than technical, he does affirm the correctness of the proposition that a breach of a covenant against assignment is not capable of remedy, and also that where premises are used for illegal or immoral purposes, you don't avoid the risk of forfeiture simply by ceasing that use. And what I take from this is that although it's right that the approach should be practical, there is a danger, and I say the judge fell into this trap in this case, that by focusing too much on the practical, you run the risk of losing focus on the gravity of the breach or the impact of the action. And one can think of perhaps examples most readily in the field of landlord and tenant. But to take the example of, let's say, a neighbour who, in breach of a covenant, subjects another resident of a property to a sustained campaign of racial vilification. If they stop that campaign, it might be said, in one sense, looking at the matter practically, they've remedied the breach. It doesn't happen again. But in another sense, in my submission, they haven't done so because they've effectively shown their hand. That relationship in the neighbour context is going to be forever soured, and the damage can't be undone. And that obviously, that example that I've taken has a resonance with the example of the immoral user example in paragraph 68. If you just focus in this context on the practical, which is what we say the judge did, you risk losing sight of other more profound matters, such as the impact of the conduct on the relationship in question.
So here, the judge did ultimately find that it was capable of being remedied and had in fact been remedied, and was, in strict terms, the difference between a company and a person exists in reality when the company was wholly owned. I've just read on to the end.
Yes.
Wholly owned by the individual. There's really no difference between them. So he seems to have been heavily influenced by the practical realities.
Oh, indeed, indeed.
Yeah.
And we don't shy away at all from the importance of the practical realities. We just say that there is a danger that in focusing on the practical realities, you lose sight of other aspects of the breach, the gravity of the breach, the state of mind with which the breach was committed. And as your lordship has, I'm sure, seen in our skeleton, just reverting from this look at the authorities to the present case, we say the judge's treatment of what Gwent did put it on a par with a situation where the 1651 breaches shares were allocated to Gwent as a matter of pure administrative error, an innocent error by a junior employee in the organisation. The way the judge approached it was to say, well, if the shares can be returned, no harm is done. And effectively, I'll come on to this when I develop my submissions on the facts. Essentially, he treated the way Gwent behaved with that purely administrative act of the kind that I allude to. And we say that just can't be, that's a false equivalence. That can't be right. It can't be right just to look at the practical effects to the exclusion of things like stigma we see here, or impact on the underlying relationship, or other more perhaps nebulous concerns, but which are concerns nevertheless. As I say, I'll come on to this when I develop my submissions on the irremediability of the individual breaches in this case. But for the moment, and focusing on the authority, this is what we take from Aichi, that it's not just about making sure it doesn't happen again.
And you say, in summary, breaches were of a kind which were intentional. They weren't just administrative and innocent, and they went to the very heart of the relationship.
My lady, absolutely. So, just to finish on the authorities, the next one in time is Force India. We've obviously looked at this in a different context. I will, if I may, just take the court back to paragraph 108 of that decision, which is on page 312 of the authorities bundle. This is a slightly different perspective, if I can put it that way, on the same point. The court will recall that the breaches in this case were the publication of confidential information or the publishing of advertising matter not containing a party's name. And it's another instance of the point I've just made. You can, as a practical measure, redress those. You can make sure that for the future, advertisements contain the right name, and you can change the livery on the cars. But again, merely by doing so, as the Court of Appeal held in this case, you do not remedy the breach. So I take the same point from this, albeit in the context of a slightly different, breaches of a slightly different nature. Focus on the practicalities by all means, but not to the exclusion of other impacts of the breach. We've looked at Force India in some detail this morning, and I don't propose to spend any more time on that case. And so we come to the last case in this sequence, Wickland Holdings and Telca, which is at page 431 of the authorities bundle. A decision of the Supreme Court from 2014, Baroness Hale, Lords Wilson, Reed, Carnot and Tolson. This was a case involving antisocial behaviour at a caravan park and engaging the provisions of the Mobile Homes Act 1983. And the facts were these. Antisocial behaviour was committed by a resident in 2006. A letter was sent to him in 2006 requesting him to desist. There was no further breach until 2009. On the occurrence of that further breach, the claimant sought possession. Now, the difficulty in this case arose from the wording of the relevant paragraph of Schedule 1 to the Mobile Homes Act. And the court can find that in paragraph 1 of the speech of Lord Wilson on page 4007 of the report, 433 of the authorities bundle. And at letter D in paragraph 1, Lord Wilson sets out the paragraph in question, and on reading it one can see the problem straight away. That paragraph is predicated on a notice to remedy being given and not being complied with in a reasonable time. Of course, it wasn't quite apt to fit the facts that had arisen, because the notice had been complied with in the sense that the nuisance behaviour had stopped, but then it reoccurred. Now, the court at first instance and the Court of Appeal ordered for possession, but the Supreme Court unanimously allowed the appeal, but they reached their conclusion by differing routes. The view of the majority, which was Baroness Hale and Lords Wilson and Toulson, was that the notice lapsed after a reasonable period, so that a fresh notice would be required before an act post-dating the original nuisance could form a basis for possession. The view of the minority, that's Lords Reed and Carnworth, was that the notice didn't lapse, but there had to be a causal or temporal connection between the notice to remedy and the subsequent breach, and that none was present in that particular case. So that's the sort of broad picture of the decision. In terms of passages that are relevant to the present case, I'm going to ask the court to look, please, first of all, at the speech of Lord Wilson at paragraphs 23 to 32. This is beginning on page 439 of the authorities bundle, and is concerned with the question of whether a breach is capable of remedy. And in this passage, Lord Wilson considers, first of all, breaches as a positive obligation, that he says don't present any particular difficulties. If it hasn't been done, you give a notice, and if it isn't done within a reasonable time, you can seek possession. But what about breach of a negative obligation? He asks rhetorically at paragraph 25. And he goes through, in that context, some of the landlord and tenant authorities about stigma, the rugby school case, which was also mentioned by Lord Justice Neuberger in Aichi, Savo and Hussein that we've looked at, that's paragraph 28, and Aichi and Butlin, which we've also looked at in paragraph 29. And the paragraph that I draw place reliance on is paragraph 31. Can I just ask the court to read paragraph 31? Yeah.
You need to look at paragraph 30 as well, don't you? Because he draws a distinction between a negative breach, not to build a shed, and the nature of the obligation in this case, which is not to annoy or disturb other occupiers. And what he did was jump out in a mask and camouflage uniform and frightened an elderly resident.
Yes. My lord, the whole of the passage from 23 to 32 is relevant. The focus I'm going to take is mainly from paragraph 31, but as your lordship helpfully points out, paragraph 30 as well. And it picks up on the point I've endeavoured to make, that there is more to the question of remedy than just asking whether, as a practical matter, things can be put right. And the reason paragraph 31 is significant, and this was a passage to which I took the judge at first instance, but did not find expression in his judgment, is that really that begins below letter B in paragraph 31. Had Mr. Talcadder not only jumped out at Miss Puncher, but, for example, deliberately perpetrated a significant injury on her, Wickland might well have been entitled to conclude the breach was irremediable. There was therefore no need for it to serve a notice to remedy, that it should apply directly to the court, and so on and so forth. Now, it's the same idea that I've been trying to develop. In both cases, one might say the injury, I mean, of course, Lord Wilson does refer to a physical injury, and I take the point that that's a distinction. But what he's really focusing on is the deliberate nature of the perpetration of that injury.
You've got to look at that. He does go on about the nature of the covenant, and the nature of the covenant is not to annoy or disturb. And when you do things that do annoy or disturb, then you look at it, and clearly if you do really serious things to annoy and disturb, but you can't entirely separate out the nature of the obligation and the thing that is said to breach it. Not moving outside that to completely unrelated events.
Well, my lord, I completely take the point that this is a very different context. But I do say that I'm entitled to take from this, as indeed I've sought to take from some of the other authorities that we've just looked at, like Phoenix Media and Aichi, that one must concern oneself, at least to an extent, with the nature of the act committed. Not merely its practical effects, but the motivation and its impact on the victim, very much as Lady Justice Asplin put to me a few moments ago, which summarises my case in this respect perfectly. I do take the point that this is a very different context, about as different as it's possible to imagine. But I do also maintain that that same theme can be found in this judgment. And it's not just about the level of the annoyance or the level of the injury. It's about the disposition with which the act was committed.
It's ultimately about whether a breach of an obligation can be remedied. And when you're looking at the breach of an obligation, you see what the obligation was and see what happened to breach it and see what can or would be necessary to remedy that breach. So you've got to look at the clause to see what you're remedying. It's not a punishment thing. He's a really bad person. Any breach is awful. You've got to look at the breach and see what the result of the breach is.
My lord, I hope I don't shy away.
No, but you say you look at other things
from the context, yeah. But one looks at other things as well.
Yeah.
I think that's the key, if rather inelegantly expressed point. To the same effect, if we could look at paragraphs 48 to 49. This is now in the speech of Baroness Hale. Baroness Hale again draws the distinction between negative obligations, or some negative obligations, and others. And she says at letter C, it's not so easy to see how a breach of a covenant not to annoy or disturb other residents can be put right. But I agree with Lord Wilson and Lord Toulson that an incident such as that on 31st July 2006 can be put right by refraining from such behaviour for a reasonable time enough for the fears and anxieties it caused to calm down. And she says at paragraph 49 that this is the majority view and constitutes the ratio decidendi of this case. And then I think just the last paragraph, 52 to 53. And my Lord Justice Lewis may think this rather vindicates the point he just made. Lord Toulson says at paragraph 52, the answer to the first question, which is what is required to remedy a breach, is a practical approach, that is, whether and how the mischief caused by the breach can be redressed. The context is a relationship between an occupier of land and the owner of the land, who also has responsibilities towards others living in close proximity. Now, again, that emphasises the point that we are concerned with a very different context here. But I say that does not denude my submission of all force. We've seen how in other contexts too, including the purely commercial and landlord and tenant, one is concerned to look at more than simply the practical cessation of the offending behaviour. And we say that what we say is the obvious point, that a breach can be of greater or lesser magnitude, and the greater the magnitude, the more deliberate the breach, the harder it is to remedy, essentially the way that Lady Justice Asplin summarised our case a few moments ago. So against that exploration of the authorities, I turn hopefully quite quickly to grounds 5, 6 and 7. We put the point in different ways, trying to identify what we say are different errors of law in the judgment. And I will ask you now, if you would, to go back to the judgment. The first complaint is the judge's failure to take into account the pre-existing relationship between Mr. David Lewis and Mr. Kulkarni. This is dealt with at paragraph 436 onwards of the judgment on page 151 of the core bundle. And in paragraphs 436 and 437, the learned judge helpfully summarises the submission that I advanced and his response to it. He equated my submission that the social relationship had a part to play to the quasi-partnership case. It's not a parallel I myself particularly draw. I just say that the social relationship is a part, albeit an important part, of the factual matrix against which this contract must be construed. The judge gives his reasons then for rejecting the submission. At 438, he says that there's a pleading point, and it's true that it wasn't precisely this relationship that was referred to in the particulars of claim drafted by my predecessor. Nevertheless, it's a point that I submit was open to me at trial. It's part of the factual matrix against which the shareholders' agreement should be construed, and indeed it would be artificial to exclude it on a pleading or any other basis. The second point the judge makes at paragraph 439 is that the SHA was based on a standard form precedent and is of a type that is commonly used in commercial transactions. And he says, in his experience, such agreements are used where there is no particular relationship between the parties and so on. In my submission, that puts the cart before the horse. Whether it's a standard agreement or not, the factual matrix against which the agreement was made was one in which there is a close personal relationship between Mr. Kulkarni and Mr. David Lewis, who is admitted to be the shadow director and controlling mind of Gwent Holdings. So the fact that it's a standard agreement does not denude that social relationship of relevance in the way that the judge seems to have considered that it did at paragraph 439. The same is true of the absence of any term of express term of trust and confidence. This is a point that the judge moves on to at paragraph 442.
What about 441?
Well, 441, I think I can fairly describe as a continuation of the second reason. And you'll see that the judge goes on to say at 442, the third issue for Mr. Kulkarni is what the SHA does not contain. And he says it doesn't contain any express or implied duty of trust and confidence. That is true. I've made my submissions about that in the context of the Phoenix media case. We say the fact that the contract doesn't include any such obligation does not relegate the trust and confidence between the parties to the status of an irrelevance. And in paragraph 443, the judge goes on to say that Mr. Lewis was acting in his own commercial interests and was entitled to do so. This was conceded reluctantly by Mr. Kulkarni, not because of any sense of friendship for Mr. Lewis, but because he had no choice. Now, we absolutely accept that Mr. Lewis, in causing Gwent to enter the agreement, was looking to his commercial interests, and furthermore, that he was entitled to do so. The problem is this doesn't address the consequences of a breach. If you adhere to the contract, looking after your own interests is, of course, your prerogative. Exercising a discretion under the contract, likewise, you don't have to exercise it in the best interests of your contractual counterparty, unless that's what the contract says. But if you breach a contract against this particular factual matrix, you have a problem, because remedying that breach is going to be much more difficult where there is a close pre-existing personal relationship than would be the case if this was simply two commercial parties of equal bargaining power engaged in ordinary business affairs. So we say that the judge was wrong to exclude that relationship from the list of relevant considerations when he came to consider remediability. And this is all, we say, consistent with the notion that we say can be extracted from the authorities, that you don't look solely at the actions and the practical effect of the actions, but you also look at other matters such as their ongoing impact. That impact is much greater against the background of the relationship of the kind which existed here. So that, put shortly, is what we say in relation to ground 5. We say that's an error of law, not to have regard to the factual matrix in considering what is meant by capable of remedy. And I move on now to ground 6, which in some ways could perhaps be described as a sort of catch-all ground, which is that the breaches were individually and collectively, at the time of their commission, not remediable. There's a couple of general points I want to make before I develop submissions on the individual breaches. The first point is that we say that when considering what is capable of remedy, regard can and should be had to the fact that the period for remedy is 10 business days. That's a point I made before the judge, and he accepted the correctness of it. The reference in the judgment is paragraph 448, page 153. That's the first general observation. The second general observation is this: is that the breaches have to be seen as part of the continuum in which they took place. This is not to bring in to the debate about remediability matters that are extraneous to the breaches, but it's to say that the breaches have to be placed in the context in which they happened. And the highlights of that continuum are, first of all, the promise found to have been made in the pre-meeting of the 7th of February that Mr. Kulkarni could have the shares. We accept, and we've been refused permission to appeal on the challenge to the enforceability of that as a promise, but we can still draw on the fact that the promise was made. It was a promise binding in honour only, but it was dishonoured. So Mr. Kulkarni expected to have his shares paid for, and they were not. Then, post the shareholders agreement, there was the conduct of Andy Lewis. That's described in the judgment at paragraphs 239 to 283. It doesn't need repeating, and I know the court has read it. But it was, as the judge's language reflects, serious, and it had a considerable impact, as the judge also recognised, on Mr. Kulkarni, who lost his employment, his directorship, and his entitlement to shareholding in an institution to which he was deeply wedded. So the continuum, the context in which the breaches take place, is, we say, important and needs to be kept in mind in considering whether or not the breaches are remediable. Despite this, if we could look at paragraph 455 of the judgment, we see the approach that the judge adopted. He reduces the test, we say, too much to the practical. The question he asks himself is, could the breach be put right for the future? He says the practicalities are significant, and he says, as a practical matter, it was plainly straightforward to reverse the allotment and issue of both the A and the B shares. Now, we'll come on to the individual breaches momentarily, but just focusing on the general for the moment, he goes on to say that reversing an erroneous allotment and issue of shares to Gwent could not, in my view, reasonably be said to give rise to a conflict of interest, and essentially reduces the question of remediability to the simple question of whether the shares could be returned. That takes practicality too far, we submit, leaving aside the fact that this process took much longer than the 10 business days which were provided for remedy by clause 7.1d. It equates, as I've already submitted, what Gwent did with the same result being achieved purely by an administrative error, being identified straight away and put right. That might be remediable. What Gwent actually did, seen in context, was not. So those are the general observations as to collective remediability, if I can put it in that way. And I focus now on the individual breaches, starting with the A shares breach and the B shares breach. I set out the chronology this morning. Gwent took ownership of the A shares to which Mr. Kulkarni was entitled on the 21st of August, and they held on to them until the 26th of October 2021. That's 21st of August 2020 to 26th of October 2021. Within that time, they faced down Mr. Kulkarni's protestations by his solicitor's letter of the 21st of May 2021, doubling down their position. Both the A shares breach and the B shares breach were remedied by the expedient of putting the shares back into Treasury. That process, as had been foreshadowed in VWV's, Osborne Clark's letter, I think, of, Clark Wilmot's, thank you, third time lucky. Clark Wilmot's letter of the 24th of September, paragraph 26, is a process that they said was likely to take a number of weeks, and indeed did take a number of weeks. It required written resolutions to be passed, giving 28 days for shareholders to respond, stamp duty to be paid, and the SH03 form to be filed. So remedying even the A shares breach by putting the shares back was always likely to take more than 10 business days, and that affects the question as whether, even as a purely practical matter, that could ever have been achieved in the 10 business days contemplated by clause 7.1d. The same route was taken in relation to the B shares breach. Gwent, of course, had taken 2,000 B shares that wasn't so much they weren't entitled to, but if they were going to take an allotment of B shares under the provisions of Section 651 of the Companies Act, they had to offer, or SJIH had to offer, a proportionate share to Mr. Kulkarni, which is 980 B shares, reflecting the 49.51% of their shareholdings. Now, we say the B shares breach is not really remedied, unlike the A shares breach, just by putting the shares back. The wrong done to Mr. Kulkarni consisted of an allotment being taken without his being offered the opportunity to subscribe. And he should have been entitled to do that. The route taken essentially consists of pretending the allocation didn't happen, but it did. And simply putting the shares back doesn't undo that, not least because there was simultaneously an allotment of 1,235 B shares to the consultants, and they still have theirs. I don't say that that is the thrust of our breach. That's something that the shareholders agreement contemplated would happen, but it does go to the question of whether simply putting the 2,000 shares back constitutes remedy in any event. So even focusing on the purely practical and leaving aside the wider considerations that I say should colour the question of remedy as well, these two breaches were not individually remediable, I would say, at all, and certainly not within the 10-day period that the shareholders agreement contemplated. So far as the termination breach is concerned, the letter that we looked at this morning, page 148 of the supplemental bundle, was the origin of that breach, 28th of August, and that continued until Gwent acknowledged the continuation of the shareholders agreement, which they did on the 27th of September 2021. So more than a year during which they treated the shareholders agreement wrongly as being at an end. The letter of termination was, we say, spurious. The breach was, of course, very long-lasting, and like the A and B shares breach, was doubled down upon in that period when VWV responded in the terms they did to the correspondence sent by Mr. Kulkarni's then solicitors and levelled at Mr. Kulkarni the accusation of fraudulent misrepresentation. So, of course, while we recognise that the judge, and indeed respectfully agree with the learned judge when he said that in a way the termination breach is different because it was an ineffective termination. It was just an attempted termination that didn't have any impact. It is nevertheless admitted to have been a breach, and in terms of its remediability, the fact that it was so long-lasting and adhered to in the face of reasoned articulation of Mr. Kulkarni's case also has the effect of making that breach irremediable. And then finally we come on to the Hussein breach, which is qualitatively different from the other breaches because it consists of obviously a refusal to recognise the right of a shareholder to participate in the management of the company. As to that, I'd like the court please to look at the judgment at paragraphs 464 to 5, that's page 155 of the core bundle. Sorry, forgive me. It's taking a little while to get that myself. I think it's 156 of the court's, on the court's pagination, of course. The approach the judge took at paragraphs 465 to 466 were what might be described as a prejudice-style approach. He accepts at paragraph 465 that the denial of access to information on the management and affairs of Newco was wrongful. Further accept that some prejudice is likely to flow from that breach. But the test is not prejudice looking back, but rather whether the situation can be remedied going forward. And then he says these words: it's not suggested, even with Mr. Hussein having been a director for over a year, that anything has come out that Mr. Kulkarni now wishes he had known sooner. And he says it would have made no difference to the running of SJIH whatever Mr. Kulkarni might have gleaned, because Andrew Lewis had formed a clear view that he had nothing to add. In my submission, that's the wrong approach. And even if the A shares and B shares breach can be remedied by simply putting the shares back, and the termination breach can be remedied by recognising the continuing existence of the shareholders' agreement, the Hussein breach is not so easy to remedy, because 6 months have passed during which there has been no participation in the management of the company, and nothing can undo that. And this is more akin, I would submit, to the sort of breaches that were found to have occurred in Force India, the cessation of an advertising campaign, the replacement of the livery on the vehicles, the marketing campaign, as Lord Justice Ricks found there, is all of a piece. So with involvement in the management. Those 6 months will never be salvaged, and it's not right to judge that on the basis of what would have happened had Mr. Hussein been appointed. So it's a qualitatively different breach, although we say that all the breaches, both individually and collectively, were not remediable. So that's really all I want to say on ground 6. And moving on to the final ground, ground 7, I've probably developed in other contexts the points that I really want to make in relation to this. The learned judge found that all these breaches were not only material but persistent, and we say that even if the view were taken charitably that they were remediable on first commission, their persistence meant that they stopped being remediable at some juncture during that process. Now, the judge rejected that submission on the basis of the Swiss Atlantique authority, which I'll take the court to in a moment, but if I could just ask the court to look at paragraphs 467 to 473, this is on page 157 of the core bundle. The learned judge correctly recorded my submission in this context, that the persistence of the breaches had the effect of being further inimical to the trust and the relationship which Mr. Kulkarni had with the Lewis's, Gwent and SJIH. I'm looking at paragraph 468, and he repeats the points that he has made above there. He then records me as having submitted that motive can be relevant in purely commercial relationships on the basis of the Swiss Atlantique case. He goes on to accept that motive is relevant to the question of repudiation, but he says it's not relevant to any other aspect of contract law, and in so saying, we say he fell into error. So if we look at the end of paragraph 473, last 4 lines, Mr. Kulkarni's argument goes as far as saying that other conduct that is not itself a breach or even connected with the SHA more generally could be relevant. To my mind, Swiss Atlantique is not authority for such a proposition. So I just want to conclude my submissions by taking the court to Swiss Atlantique. Back in the authorities bundle, at page 10. It's a case that arises in a very different context to the present. It was an appeal against a decision made in an arbitration in a shipping dispute. And the allegation was that the respondent charterers had deliberately delayed reloading the vessel so as to reduce the number of journeys that they would make and restrict the freight payable to the owners. And it was further alleged that by doing that, they'd put themselves in repudiatory breach, and that entitled the respondents to terminate the charter. And the effect of that, it was argued, was that damages would be at large, as opposed to being governed by the liquidated damages clause in the charter. Now, the House of Lords rejected that argument on several grounds, not least the failure of the appellants to establish the implied term that they relied on. But it was in that context that Viscount Dilhorn observed that a deliberate and willful breach might take on the character of a fundamental breach. And just to show the court where that appears in the bundle, it's page 43 of the authorities bundle at 394E. And these are where we find the words cited by the judge in the passage of the judgment we've just looked at. Just at letter E, further, it was, if it was established that a breach, though not of itself sufficient duration, as to lead to the conclusion that the performance of the contract became totally different from that contemplated, was committed deliberately and willfully with the object of reducing the number of voyages accomplished, the breach might, in my opinion, take on the character of a fundamental breach. Now, the judge refers then to Lord Hodson having expressed a contrary view. In my submission, he doesn't do that at all. The words that the judge latched onto are those that can be found at the bottom of page 64 of the authorities bundle. What Lord Hodson says there at letter F is, "For myself, I see no reason to hold that attributing to the respondents a willful intention of limiting the number of contractual voyages affects the sums otherwise payable by way of demurrage so as to open the way to a claim for damages at large." But that was in the context of the argument that a repudiatory breach would have the effect of disapplying the liquidated damages clause in the charter. And what Viscount Hodson was saying was that effectively, even if the breach was a repudiatory one, it would not have that effect as a matter of law. He's not to be taken to be disagreeing with what Viscount Dilhorn said. And the last paragraph then cited by the judge to the same effect as the dicta of Viscount Dilhorn are the words of Lord Upjohn, which can be found at page 78 of the authorities bundle. And Lord Upjohn says this: "My lords, in view of the introduction in the questions posed by the arbitrator of the impact of a presumed willful default, for my part, I think it is only necessary to say that it seems to me as a matter of general principle that willful default in connection with the matters we are now considering is relevant and relevant only to one matter, that is to say whether in fact the owners can establish a fundamental breach. In cases such as this, where there has been no breach of any fundamental term, the question as to whether there has been a fundamental breach must be a question of fact and degree in all the circumstances of the case." But one of the elements in reaching a conclusion on that matter is necessarily the question of whether or not there has been a willful breach. Now, the relevance of this to the passage in the judgment that we've just been looking at.
Do we just need to read to the end of that?
Of course, my lord, yes.
Yes, I see.
Now, this could have some resonance on the submissions about remedying a repudiatory breach and the impact of state of mind to the ability to remedy, and particularly those words at the end of the paragraph where there is reference to the charters evincing an intention no longer to be bound by the terms of the contract. But the particular relevance they had in the context of ground 7 is that the judge rejected my submission that the duration of these breaches and the doubling down on Gwent's position that was evident in correspondence could cause breaches not originally incapable of remedy to become so. And the judge said effectively that ascribes considerations about Gwent's state of mind to something other than repudiatory breach. And he took Swiss Atlantique as authority for the proposition that it's only to questions of repudiatory breach that state of mind can be relevant. I submit that that's an error of law, that if in fact Gwent, having committed breaches initially capable of remedy, then being given the chance to remedy them, instead of doing so, double down on their position, that at that point in time renders those breaches incapable of remedy. So it's an alternative case that if I'm wrong in saying the breaches were not capable of remedy at the outset, I was right in saying that the breaches ceased to be capable of remedy during that period from August 2020 to September 2021. My Lords, I've taken grounds 5, 6 and 7 quite quickly, as I said I hoped I would be able to do. Your Lordships, as with all the grounds, and your Ladyship of course, have the benefit of our skeleton argument on which we rely. May I just be permitted to turn my back to ask my learned junior if there's anything that he feels I should raise? Yes, my learned junior does make a point that may be worth making. In the context of ground 4, the question of whether Mr. Kulkarni is to be treated as actually the owner of 1562 shares by estoppel might have an impact on what remedying the B shares breach looks like in the context of ground 6. Because if Mr. Kulkarni is to be treated as the owner of that number of A shares, that supports my submission that remedying the B shares breach actually consists of giving him the opportunity to subscribe for the 980 shares. Is that
follow the argument.
Did you also say you don't follow the argument?
No, I do follow the
argument. You do follow the argument. I'm very grateful. I don't think the point needs further development. My Lord, my Lady, unless I can assist further, those are my submissions.
No, I don't detect any more questions, so thank you very much, Mr. Butler. Mr. Crowe.
Very pleased to report we were going to take exactly the same route and just go through the grounds one by one. Ground 1, obviously, is the question of interpretation. The difference between us is whether the triggering event for a deemed transfer notice is the breach itself, as my learned friend would contend, or a failure to remedy the breach within 10 business days of a remediation notice being served. And we say the judge got the right answer for 8 reasons, which I will go through in a moment. But just to start with a couple of very short observations on the approach to interpretation, you are not going to need any assistance on the general approach to contractual interpretation, but we did just want to draw your attention to the observations in Coroyn on the appropriate approach to the interpretation of expropriatory contractual provisions. Coroyn is in the authorities bundle. I don't know if you're in hard copy or soft copy. So if you want the tab number, it's tab 15. Page 389 is where the decision starts. This was a dispute over whether certain transactions did or didn't involve a breach of the transfer preemption provisions in a shareholders agreement and in a company's articles of association. And we just wanted to draw your attention to the passages on page 404. We don't need the whole thing that's sidelined, but just the first 4 lines of paragraph 65. Clause 6 of the shareholders agreement and the preemption provisions in the article set out circumstances in which members may lose the right to their shares. They are therefore expropriatory in nature. Given the ambiguity in the meaning of the phrase "it becomes enforceable," which was the issue in that case, the court should, in my judgment, prefer the narrower meaning. And they then go on to say that's consistent with the approach that was taken in earlier company law cases involving restrictions on share transfers. We needn't spend time on Smith and Fawcett and so on, but if we just also look at para 67 towards the bottom of the page, in my judgment, the authorities reflect the basic principle that rights of property should not be taken away by a side wind without warrant. There's nothing to indicate that the wider view of becomes enforceable should be taken. Indeed, the high level of specificity in clause 6.6 can be said to support a meaning which covers the situation in which security is actually enforceable. So,
and just help me, is this expropriation for nothing or expropriation on disadvantageous terms or what?
I will have to get back to you on that. I can't remember the exact terms of the transfer preemption provisions there. Can I get back to you on that
Yes.
rather than trying to find the answer on my feet? What we will say when we get back to the shareholders agreement is that you'll see that the valuation is at a disadvantageous rate to the party in breach who is deemed to have served a transfer notice. So it is prejudicial. It's not just expropriatory, but it's prejudicial in the sense that it takes the lower of 2 alternative valuations. So I threatened you with 8 reasons why the judge was right. The first is just the language of the contract. If we could just get that back in front of us in the core bundle, in your pagination. You probably already got it to hand, but in your pagination, I think it's page 255. The very short point on language is simply, and this essentially was put to my learned friend in the course of his submissions, is that his argument really only works if you stop reading before the word which. If you take the whole of 7.1 and the whole of D, a shareholder is deemed to have served a transfer notice under 6.4 immediately before any of the following events. D, the shareholder committing a material or persistent breach of this agreement, which, if capable of remedy, has not been so remedied within 10 business days. In order to persuade you that the effect of this is that a transfer notice is deemed to have been served on the breach, you just have to ignore the words, which, if capable of remedy, has not been remedied within 10 business days of notice. Our submission is that it is perfectly clear from the language that the service of the transfer notice does not give the shareholder in default a contractual opportunity to remedy. What it does is to impose a deadline by which a remedy has to be made, or the deemed transfer notice is then assumed to be served. And that's got to be right, so I say just on the language and taking also the very concept of a notice to remedy the breach. It said, just looking at the last couple of lines of D, which if capable of remedy has not been so remedied within 10 business days of notice to remedy the breach being served. If there has been a breach which has already been remedied before a remediation notice has been served, the remediation notice has no function. So the contract, the provision has got to be read as assuming that a material or persistent breach can be committed and then remedied before a remediation notice is served, and no deemed transfer notice would then be served. My learned friend's only linguistic point, I think, in his skeleton argument was to latch onto the word within. And he says, well, within means starting after and finishing before the end of the 10-day period. That, with respect, simply doesn't work as a matter of language. It is perfectly clear. We're all agreed that the function of the remediation notice is to impose a deadline by which the remedy has to have been delivered. So it means within, in the sense of, by the end of, by the expiry of. But that doesn't lead to the conclusion that you are not allowed to start trying to remedy before a remediation notice is served on you, because that simply cannot be derived from the language in the agreement. As it happens, my learned friend suggested that our interpretation produces two triggering dates, because he says if there's an irremediable breach, then it's got to be the date of the breach. But if it's a remediable breach, it's the failure to have remedied it by the expiry of the 10-day period. As it happens, my learned friend's interpretation produces two triggering dates, even for remediable breaches, because on his version of events, it's the commission of a remediable breach which triggers, but then if a remediation notice is served and there is then a failure to comply, somehow failure to comply at the expiry of the 10 days it is another trigger. So with respect, the suggestion that our interpretation produces two triggers, whereas his doesn't, is simply unsustainable. The plain language, as the judge held, the plain language of the clause is that the period within which there has to be remedy is triggered by the service of remediation notice, but that does not mean that the period within which remedy can be delivered, if the defaulting shareholder wants to remedy, only starts when a remediation notice is served. So that is just the linguistic point. The second point is the structure of clause 7.1d as a whole. As we say, by definition, a remediation notice can only be served after a material and or persistent breach has been committed. If the learned friend was right, and a transfer notice is deemed to have been served immediately before the breach is committed, there would be no point in having the remediation notice being served. On that hypothesis, on his hypothesis, the mechanism for compulsory transfer under clause 6.5 would already have been put in motion. I don't think Malone...
Sorry, can I just get that again? So, what's the proposition?
The proposition is that if Malone friend is right and the triggering event is the breach,
Yep.
then there is no point in serving a remediation notice.
Well, you've got his suggestion that it might lead to an undoing of things in the future, and it's a kind of conditional
Yes.
transfer notice.
Yes. Well, I was going to go on to
Come
deal
on
with
to
the
that.
commercial implications
Yeah.
in a separate step.
There's got to be some purpose for those words. Presumably, they would have put it in for no reason.
Well, exactly so. And the purpose that we submit is the one that the judge identified, which is simply that it provides a mechanism for imposing a deadline by which there has to be remedy. It doesn't provide the commencement date by which a remedy can be provided if the shareholder in default wishes to provide a remedy.
I mean, it would be akin to section 146, wouldn't it? It would be saying if you have something that's remediable, then the transfer notice doesn't happen immediately. So that's in favour of the wrongdoing party. but then that sets a deadline, and that's really what Section 146 does too.
Yes, yes, yes. Yeah. So the third point we just wanted to suggest is that the suggestion that the service of the transfer notice is effectively the permission granted to the shareholder in default to remedy doesn't really work because, and my friend helpfully mentions this, 2U clause 6.7 provides that a deemed transfer notice may not be withdrawn. So if it is in the context of a remediable breach, if it is the breach that triggers the service of a deemed transfer notice, then the mechanism moves and it can't be stopped. So Malone and Friends attempts to deal with this. I think he made two attempts. One is to say that there's some sort of twilight zone after the breach in which a remediation notice can be served, and then if there is remedy within the 10 days, somehow the deemed transfer notice is undone. Well, with the greatest respect, you can't imply into a contract a term which is contrary to the express terms of the contract. The express term of the contract, 6.7, says that a deemed transfer notice can't be withdrawn. So Malone Friend cannot imply a term to suggest that somehow it can be. And one might just, as a footnote to that point, remind you of clause 7.2, about which there's a certain amount of debate with my learned friend, which you will recall provides that a deemed transfer notice under 7.1d has the effect of deeming the revocation of any deemed transfer notice under 7.1a to c. So there is express provision for revocation, and that just really double underlines the point that faced with 6.7 and 7.2, you cannot imply into this contract an arrangement under which somehow a deemed transfer notice just evaporates. We also make the point, whether we need to or not, we made the point in our skeleton that even without clause 6.7, there is no coherent basis for introducing some imaginary concept of undoing a transfer notice. It is just conceptually, there's just nothing for that proposition to hang on to. And the third point we make in our skeleton, which I just wanted to emphasise now, is that the solution that the appellant is trying to put in front of you in this regard produces uncertainty in at least two respects. One is, how long does this twilight period last? For how long after a deemed transfer notice has been served is the board entitled then to defer and then later serve a transfer notice enabling the shareholder in default to try remedying things? The answer to that question simply isn't there. So it is wrong as a matter of principle to interpret a contract in a way which produces uncertainty, particularly where it seeks to do so by introducing a term which is inconsistent with the express terms of the contract. The only other attempt that my learned friend has made to deal with the difficulty that his interpretation produces is in what he made the point on his feet. It's in paragraph 51 of his skeleton as well. We probably don't need to go back to it, but that's where he mentions it. And that is that if the non-defaulting shareholders are happy for the defaulting shareholder to hang on to his shares, they can simply not take the point. They can just ignore the fact that a transfer notice has been served. Well, again, that is simply not a realistic basis to propose the interpretation of a commercial contract. If the interpretation produces an outcome under which the parties have to pretend that the operation of the contract isn't as it in fact is, or according to their version of events, that very strongly suggests that is not the correct interpretation. And contractual uncertainty, it doesn't just end there. If it is the case that the party in default is deemed to have served a transfer notice immediately before the breach,
When you say immediately before the breach, why would it be before?
Well, that's what it says, oddly.
Is it?
7.1, a shareholder is deemed to have served a transfer notice under
before,
immediately
yes,
before
right. Yes,
any of the
okay.
following events.
No, I see your point.
It's presumably, well, it is one of these sort of slightly catch-all clauses. It's presumably dealt with, it's got its eyes on death and bankruptcy. I suspect is why it says immediately before. It doesn't work beautifully with D, but
No,
I imagine that's why that language was used. But it may well be, sorry, just going back to my next uncertainty point, it may well be that either the contract breaker doesn't realise they have committed a material breach, or that the innocent parties don't appreciate that the breach, albeit they may know there's a breach, they may not know there's a breach, they may not know it's material. But on the appellant's interpretation, even though the contracting parties may be unaware, the transfer preemption mechanism has already been put in motion by the breach. So that produces uncertainty, because it means that according to the appellant, the forced transfer of the shares has been put in motion without the parties actually knowing it. By contrast, the judge's interpretation produces contractual certainty, because the deemed transfer notice is only triggered if there is a remediation notice which is then not complied with within 10 days. Contractual uncertainty, I think, was my fourth point. The fifth point is the expropriatory effect of the clause, and I simply invoke the passage we've seen from Coroyn. The interpretation offered by the appellant has the effect of depriving a shareholder in default of the opportunity of remedying the breach. It therefore provides an expansive interpretation of the expropriatory provision. The judge's interpretation, in our submission entirely correctly, adopts a more restrictive approach by accepting that the transfer notice is only deemed to have been served is only deemed to have been served in the event of non-compliance with a remediation notice. And so, taking the Coroyn approach, we submit that that provides fortification for the judge's interpretation. Number 6, the function of clause 7.1d. We would suggest that it is obvious that the function of this particular provision is to provide an incentive for the parties to the shareholders' agreement to comply with their contractual obligations. Because in the event of persistent or material non-compliance, there is the threat of expropriation hanging over their heads. If you accept that, in our submission you should, if you accept that that is the function to encourage compliance with contractual obligations, the appellant's interpretation would frustrate that purpose, because it would mean that a shareholder who wants to remedy can't, unless someone else, the company, chooses to serve a remediation notice. So instead of operating as an incentive to compliance, it would operate as a form of potential weapon in the hands of the non-defaulting shareholders. Which leads into issue 7, which is commercial common sense. And my learned friend's already faced up to one of these points. He accepts that his interpretation leaves a defaulting shareholder who immediately takes steps to remedy a material or persistent breach without waiting for a remediation notice in a worse position than an obdurate contract breaker who does nothing until service of a remediation notice. That, with the greatest respect, cannot be a sensible interpretation of the contract. His various answers to that difficulty are, first of all, he says, well, yes, it is an odd outcome, but it's not so odd as to overcome the natural meaning of the words. Well, that doesn't do him any good unless he's already won on what the natural meaning of the words actually is. And it also, with respect, displays a failure to adopt the correct approach to contractual interpretation, which is, in the case of any ambiguity, to take into account the commercial implications of the competing arguments. So if Milène Friend accepts that there is, and with respect, it would be unwise not to, that there is some degree of ambiguity in the clause, then the commercial implications of each of the competing arguments have got to be taken into account in deciding which is the correct interpretation. The second point Milène Friend makes is to say that the judge's interpretation results in the defaulting shareholder being able to decide whether they can remedy any material or persistent breach. Well, with the greatest respect, if somebody is in default and they want to remedy it, why on earth should the contract operate in a way to discourage them, or not even discourage, disable them from doing so? It would be turning a clause which, in our submission, the function is to encourage, to incentivize compliance. It would turn that clause into an obstacle course to compliance. In any event, there is, with respect, a degree of garbled logic in the argument that was advanced. Because if and when a remediation notice is served, it is, at that point, up to the defaulting shareholder to remedy. So even on Milène Friend's version of events, the ability to remedy plainly is in the hands of the contract breaker, is the only person who can provide a remedy. So if they have that opportunity after the service of a remediation notice, why on earth not earlier? But in any event, as I say, our main point under this heading is that the function of clause 7.1d is not to punish a shareholder for a breach, but to act as an incentive for them, to encourage them either not to break or to remedy any breach as rapidly as possible. And the final point, just answering that response of Milène Friend, where he says that the ability to remedy, so to speak, or the ability to choose whether a breach should be remedied, should be left in the hands of the non-defaulting shareholders, he's actually dodged the complaints that we make, which he acknowledges, which is that his interpretation puts the obdurate contract breaker in a better position than the party who's willing to remedy. And further, his response also betrays the second respect in which his interpretation produces uncommercial results, because it would result, his interpretation would result in the non-defaulting shareholders having the ability to prevent a defaulting shareholder from remedying any breach. You will recall the requirement for shareholder consent to be given before a remediation notice is served. You will recall that shareholder consent requires the shareholder whose actions are in question, so to speak, to be disregarded. So shareholder consent is entirely in the hands of the non-defaulting shareholders, the innocent shareholders. So they can simply refuse to provide shareholder consent to the issue of a remediation notice, which means that they can use the contract to expropriate the shares of a shareholder in default who wishes to remedy the breach. And that, in our submission, is simply not a sensible interpretation of the contract. That, I think, was a 7th point. The 8th point we just wanted to mention is that although it was not dealt with as part of the ratio, it is clear from the decision in Force India that the assumption was made that with a clause such as this, there has to have been a notice, even, sorry, shall I just take to the relevant provision? So, Force India, it's in the authorities finding tab 12, and at page 307. It is apparent that the case, and I quite accept this is not part of the ratio, but it is apparent that the case proceeded on the assumed basis that it wasn't the breach that would prompt the operation of the clause in that case, it was the failure to comply with a remediation notice. And I get that from the sentence, I don't complain at all, but it's the sentence my learned friend didn't read in paragraph 84, page 307, paragraph 84. The judge has gone through the question, and then you'll see, well, it is helpful just to pick it up, take the whole paragraph. I put the question this way since Mr. All's submission is that if Force India had committed an irremediable repudiatory breach, then the sponsors were entitled to accept it under common law, irrespective of clause 12.1. I think that's correct. Clause 21, upon analysis, does not apply to irremediable breach, only to a material but remediable breach. No written notice is required of an irremediable repudiatory breach. Since no notice under clause 21.3.1a was ever given calling for remedy within 10 days of a remediable breach, the sponsors cannot and do not rely on that clause. And that clause was the one my learned friend took you to. It was quoted at the top of page 282. So it's apparent from that, and I accept it wasn't argued and it's not part of the ratio, but it is perfectly apparent from that that the judge is proceeding on the assumption that it's not the breach that triggers the clause, it's the failure to comply with the notice. And in the absence of a notice, the clause isn't triggered. And the same point is made again at the end of paragraph 86, which I think my learned friend didn't go to, so I'll just read that to you. 86, Mr. All submits that material means in context repudiatory, and that therefore 21.3.1a overlaps with the common law. Whether that is so or not, in my judgment, the subclause only deals with remediable breaches. Mr. Auld accepts that if the breaches complained about are remediable, then the sponsors must lose on liability, for no notice to remedy was ever given. So again, I entirely accept that this is on the basis of counsel's concession, but it is perfectly clear that that case was argued vigorously on the assumption that a clause such as ours is triggered not by the breach, but by failure to comply with a notice of remediation. Just a couple of short responses to the counter-arguments my learned friend has advanced. Very briefly, there's a suggestion made, my learned friend didn't really develop this in his oral submissions, but in his written skeleton at paragraph 49, I don't ask him to go to it, but in his skeleton at paragraph 49, he says that on the judge's interpretation, a material or persistent breach is of no consequence unless a remediation notice is served. And with respect, that is plainly not correct. And if we could just make three very short points in response. On the judge's first, on the judge's interpretation, if a material or persistent breach is committed which is repudiatory, the non-defaulting shareholder can accept the repudiation and the contract would come to an end. Second, on the judge's interpretation, if a material or persistent breach is committed but no remediation notice is served, the non-defaulting party can sue for any damages caused by the breach, irrespective of whether it is repudiatory or not. My learned friends seem to think that there is only one acceptable outcome, which is the triggering of the transfer preemption provisions. But there are other contractual remedies available, and damages for breach is one of them. This is a point we made in our written skeleton. I don't ask you to go back to it. It's paragraph 13.1. What we didn't do in our skeleton was to cite the authority which my learned friend has gone to for this purpose. Swiss Atlantique explains, you probably don't need authority for it, but there is just a passage in Swiss Atlantique in the, I won't ask you to go to it, but it's in the report. It's page 421F in the authorities bundle that we have. It's tab 3, page 70, and it makes exactly this point that that damages are available in relation to breaches which are repudiatory, even if the contract is then affirmed. It doesn't deprive you of your ability to sue for damages, and plainly if you accept the repudiation, then you can sue for damages as well on that basis, and you can sue if the breach is not repudiatory. And the third point as to why it is wrong to say that on the judge's interpretation a material or persistent breach is of no consequence. The third point is that on the judge's interpretation, if a material or persistent breach is committed which is remediable, and the other shareholders would wish to force remediation which is not being given voluntarily, and if the board refuses unreasonably to serve a remediation notice and the breach continues and it causes prejudice or damage, then the innocent shareholders who are dissatisfied with the board's behaviour would be perfectly entitled to bring an unfair prejudice claim under section 994 of the Companies Act, or a derivative claim against the directors for acting unreasonably in breach of their duties as directors to look after the interests of the company by refusing to serve a remediation notice, or they might present a just and equitable winding up petition, or they might make a contractual claim under the Shareholders Agreement for breach by the company itself, by Newco, as Melendran calls it, of its contractual obligations under clause 2.2 of the Shareholders Agreement to exercise its powers in a way conducive to operating the Shareholders Agreement.
Is it still not the case that on the judge's interpretation or yours, it is a serious weakness from the point of view of the non-defaulting shareholder that in the case of a breach which is capable of remedy, nothing can happen unless the board, with shareholder consent, serves a notice?
I'm not sure that's properly described as a weakness, because it is a fact that the imposition of a deadline by which there has to be remediation can only happen if the board serves the remediation notice, which they can only do if the shareholder consent is given. I mean, that is a fact under the Shareholders Agreement.
And it's not merely that you can't set a deadline, you can't activate the clause at all.
That's, yes, Yes, absolutely. But one shouldn't be looking for ways of expropriating shareholders. And this is, as I say, there are other contractual consequences of acting in breach of contract. You can be sued for damages. And if the problem is that the shareholders have given their consent, but the directors refuse to serve a termination notice because they're acting in cahoots with the shareholder in default, then you can bring proceedings for breach of fiduciary duty or for unfair prejudice. So there are solutions, but none of that, in our submission, undermines the integrity of what the judge of the judge's interpretation. And as I say, the very fact that shareholder consent is required before a remediation notice is served is actually a point in our favour, because what it means is that the non-defaulting shareholders would be able to prevent a shareholder from remedying the contract, remedying the breach if they chose to withhold that. So it's not in our submission a weakness in our interpretation. It's simply a fact of the structure, and the commercial implications of the competing arguments are a matter for you to assess.
I do follow how you put it, and that I follow how your case is rooted in the clause. As we've been looking through the authorities, we've obviously seen clauses with very comparable wording.
Yeah.
But normally with the ability of the innocent party to serve a notice, and this is different.
Well, this is yes, because partly because it's not a purely bilateral contract.
Yes.
So it is a function of the fact that this is a shareholders agreement. Can I just also, actually, just having made that point, answer incidentally a point my learned friend made, which is he seemed to suggest that there was some objection to repudiation, because I think he said it would leave a shareholder in limbo if the terms of the shareholders agreement didn't apply to them. With the greatest respect, that is simply not true. The relationship between shareholders inter se and between shareholders and the company are governed by the Articles of Association. You don't have to have a shareholders agreement. If the outcome of a particular set of facts is that a shareholders agreement has been repudiated and the repudiation is accepted, well, so be it. You don't have a shareholders agreement anymore. That doesn't mean that the parties are in limbo. It just means that their relationship in the company is then governed by the articles and not by the shareholders agreement.
I haven't worked out how it would work with multiple shareholders. I mean, it is a multilateral arrangement, potentially.
Yes. Yes. No. Well, that wasn't a point that was argued at trial, and it doesn't feature in the judgment. And the answer is quite probably that individual parties to a shareholders agreement can drop out through repudiation. The final point I just wanted to answer that was advanced by my learned friend, he says that, and this is again paragraph 49 of his skeleton, he says that if the defaulting shareholder is in the majority, they could prevail on the board not to serve a remediation notice, thereby preventing the 10-day period from running. That, in our submission, is a false line of argument, because it seeks to sort of sustain one interpretation of the contract by reference to a particular set of facts, namely, if the defaulting shareholder is in the majority. If the defaulting shareholder is in the minority, my learned friend's point doesn't run. You can't use one set of assumed facts rather than another to urge the interpretation of a contract, because that's got essentially to be construed, in a sense, blind to potential facts. But, as I say, more importantly, is the point that we've already made, which is that on the appellant's interpretation, the non-defaulting shareholder in all cases would be able to refuse shareholder consent and thereby prevent a shareholder that was in default and willing to remedy, would be able to prevent them from remedying any breach. So those are the reasons why we say the judge was right in relation to the interpretation of the clause. Now I was going to move on to ground 2, which is this point of principle as to whether a repudiatory breach of contract is ever capable of remedy within the meaning of clause 7.1d. It is apparent, as you have seen from the case law, that the answer to this turns on interpretation. And we say that the judge came to the right answer. And we say that essentially by reference, I'm going to address you under 3 headings. The first is the conceptual difference between the consequences of a repudiatory breach of contract under general law and the question of construction in relation to any particular contract as to whether a particular breach is capable of being remedied. So, conceptual difference there. Second heading is to look at the case law on what capable of remedy means in relation to a contract with a provision such as ours in 7.1d. And the third point is then to turn to the language of this shareholders agreement. So taking those 3 issues in turn, under the general law, the repudiation of a contract by one party vests in the other party a right. When the word is used, we'll go very briefly back to the case law. It vests in the other party a right to elect between either affirming the contract or accepting the repudiation. Obviously, if the non-defaulting party accepts the repudiation, the contract comes to an end. If they affirm the contract, then it continues to bind the parties according to its terms. The points in the analysis, which I'm sure are obvious but worth underlining, are that a repudiatory breach does not of itself bring the contract to an end, and the corollary to that, if the contract is affirmed, its terms continue to bind the parties. What is clear from the case law is that the defaulting party cannot deprive the non-defaulting party of the right to elect between affirming the contract or accepting the repudiation. That is what Bournemouth University and Wickland is about. And I don't want to get hung up on labels, whether we use the word cure or remedy. That is potentially capable of confusing the underlying concept, because it is clear in our submission that the concept that Wickland is dealing with is that where you're talking about repudiation of a contract, the result of one party repudiating a contract is that the other party gets a right, the right to elect. And what the defaulting party can't then do is to take away that right. And I know you've just been to Bournemouth and Wickland quite recently, but I just emphasise that the passages where we say that is apparent and that is the issue it's dealing with, not the issue that the judge was dealing with in our case. So Bournemouth and Wickland, in the authorities volume at tab 13, and my learned friend picked it up, I think, at the bottom, page 333, where, as the heading happens to use, the word cured. Can a repudiatory breach be cured for acceptance? And if so, was this one cured? So I say, I don't think that one should get too preoccupied by the language in which it is described. What is important is to see what the concept that is actually being grappled with. And that is apparent if we go on to page 335. you'll see the long quote that Milena Friend read to you from Stocznia Gdanska and Latvian Shipping. And I just wanted to emphasize in the last 4 lines of that indented quote, just above letter D, he also runs this. This is the dithering non-defaulting shareholder, if that's the right word, that the party in repudiation will resume performance of the contract and thus end any continuing right in the innocent party to elect to accept the former repudiation as terminating the contract. And the word right, the innocent party's right to go, is how Lord Justice Jacob described it also in paragraph 52, just above letter E. Once he's committed a breach of contract which is so serious that it entitles the innocent party to walk away from it, I see no reason for the law to take away the innocent party's right to go. So that is the concept with which Buckland is dealing. Repudiation confers on the innocent party a right, and if the defaulting party then starts complying with his contract, that can't take away the right. That is an entirely different concept from what we are dealing with, which is where a contract describes a category of breach which is remediable. And it is apparent that these are different concepts, because if one then looks at the test for remediability, where a contract includes a clause which uses that expression, capable of remedy, it is perfectly clear that what it is talking about is a situation where, irrespective of how serious the breach is, for the future, it can be made good in a practical way, a non-technical way. And that is the test that's applied in Schuller and Wickman. And again, you've seen that recently, but if we can just go back to it very briefly. So it's Authorities tab 4. And I think we were shown the contractual clause at 101, bottom of 101. If I could just remind you of what it said at page 102 at letter G. It appears to me that clause 11A(1) is intended to apply to all material breaches of the agreement which are capable of being remedied. The question then is what is meant in this context by the word remedy. It could mean obviate or nullify the effect of a breach so that any damage already done is in some way made good, or it could mean cure so that matters are put right for the future. I think that the latter is the more natural meaning. He then goes on to make the observation, which I think is worth it, bearing in mind the way the argument under ground 6 is run. The word is commonly used in connection with diseases or ailments, and they would normally be said to be remedied if they were cured, although no cure can remove the past effect or result in the disease before the cure took place. And in general, it can only be in a rare case that any remedy of something that has gone wrong in the performance of a continuing positive obligation will, in addition to putting it right for the future, remove or nullify damage already incurred before the remedy was applied. To restrict the meaning of the remedy to cases where all damage, past and future, can be put right would leave hardly any scope at all for this clause. And in our submission, that is a useful and important analysis, and it is the correct approach when you're looking at whether or not whether a breach is capable of remedy as a matter of the contractual language of any particular provision. The only other thing I just wanted to draw to your attention, because it fortifies our argument a little bit on ground 1, is at page 104, letter E. There's a very short passage. It's fairly trite, but since it's here, I'll read it. The fact that a particular construction leads to a very unreasonable result must be a relevant consideration. The more unreasonable the result, the more unlikely it is that the parties can have intended it, and if they do intend it, the more necessary it is that they shall have made that intention abundantly clear. And in our submission, that is a useful reminder, and it feeds into the interpretation under ground one, and why we say the appellant's interpretation should not be accepted, producing the result that it does of depriving a shareholder that is willing to remedy of the opportunity to do so. So that essentially is the test. Can I just mention a point of almost no consequence, but I feel I just wanted to correct. There is a very small typo in our skeleton. It may not be necessary to get it out, but it's in paragraph 18. The passage, which is, if you've got it in the bundle, it's page, I think, 282 in your pagination. The words capable of remedy require very little gloss, we say. The test has universally been applied in the case law, certainly since Schuller and Wickman, is whether the breach can be put right for the future. The inverted commas should appear there. They should be closed at that point, is what I mean. The words in a practical and non-technical sense is actually a gloss that comes from Aichi. We've included it in italics as if it was part of the quote in Schuller, which it wasn't, so I apologise for that. But that is what one gets from Aichi, and again, it may just be convenient to go to that. Again, you've seen it recently, and I just want to emphasise very briefly a couple of short passages to make clear that the concepts with which this line of authorities are dealing are entirely distinct from Buckland, Bournemouth and Buckland, because they are dealing with the meaning of a contractual term capable of remedy, not with the concept under the general law of taking away the innocent party's right to elect between accepting a repudiation or affirming the contract. So Aichi and Buckland is tab 11 of the authorities bundle. It starts at page 254. Just for note, there's a little bit of further support for the Coroyn approach at page 261. I won't ask you to read it now, but on page 261, paragraph 30, there's again reference to the idea that a strict interpretation should be applied to covenants which have severe consequences. It's not actually an expropriatory case, it's a forfeiture case, but in any event, it's of a piece with the approach taken in Coroyn, is that if the consequences of a particular contractual provision are significantly adverse to one party, then it is appropriate to take a strict or narrow approach to the interpretation. And then the main passage, I think your attention has been drawn, but I just wanted to emphasise a couple of points on page 267. In paragraph 63, my learned friend commended to you the whole, I think, of 62 to 65, but could I just particularly draw to your attention paragraph 63, where just below letter B, Lord Justice Newberger, as he then was, says, it seems to me that there are two principal purposes of section 146 in relation to forfeiture clauses and leases. The first is to enable a lessee in breach of covenant to have the opportunity to remedy the breach where that is possible, and thereby to avoid forfeiture altogether. And that, again, is a useful reminder of, and is, as we would submit, of a piece with our approach to the interpretation of clause 7.1d, which is there not as a sort of booby trap to make life more difficult for a contract breaker who is willing to remedy, but as an incentive not to breach, or if broken, to remedy. And then paragraph 64, just to underline the point of principle that one gets from these. In those circumstances, it seems to me that the proper approach to the question whether or not a breach is capable of remedy should be practical rather than technical. In a sense, and again it's worth emphasising this, any breach of covenant is, strictly speaking, incapable of remedy. And then he goes on to discuss those. It says that that's not the point. One is looking at a practical and technical, and as we saw from Schuller, making good for the future. And then at 65, he says, in principle, I would have thought that the great majority of breaches of covenant would be capable of remedy in the same way as repairing almost user covenant breaches. And then, the only other thing that's just worth perhaps glancing at is paragraph 85, because this will have some relevance when we get on to grounds 5, 6 and 7. We just look very briefly at paragraph 85. On the facts of this case, what the judge, the Court of Appeal says at 85, given that the judge made no finding on the issue of whether, if remediable, the breach in this case was remedied in a reasonable time, I do not think that we should do so in this court unless it's necessary to determine this appeal or possibly relevant on the issue of costs. That is because the arguments are quite finely balanced. Their resolution may depend on a detailed analysis of some of the evidence and of company practice, and this is very much a matter for the trial judge. I would therefore leave that aspect of the issue of whether the breach is remedied open. I just wanted to emphasise that because whether or not a breach is capable of remedy is not a point of law on which it can be said there is a right and a wrong answer in any given case. It is a matter of evaluation. As one of the cases said, it's a value judgment. Wickland and Telchadder, as we'll see in a moment. It's a value judgment. And that, in our submission, is extremely important when you come to address grounds 5, 6 and 7, because it informs the test that you should be applying. You're not, in the nicest possible way, you're not the trial judge. You're not making up a decision with a blank sheet of paper. You're hearing an appeal as to whether this judge got it wrong. And so that's an important point there. So that is what we wanted to get from Aichi. And then partly just for that value judgment quote, I was going to go back very briefly to Wickland and Telchadder, which is at tab 16. I should have asked what time you were proposing to finish. I'm sorry.
Assuming we're not running late.
No, we're not.
I don't think we are.
No.
Then 4:15.
Perfect. And I'll deal with this and then probably actually draw stumps. So Wickland and Telchadder, this is the mobile homes misbehaviour. And we just wanted to remind you that your attention was drawn to the relevant sequence of the discussion of the various cases, the Savran Hussein and Aichi and so on, starting at page 439 in the bundle. And I just wanted to emphasise the opening words of paragraph 31 at the top of page 441. And this is, I think, a point my Lord Justice Lewis was putting to my learned friend. In my view, the answer is to be found by a practical inquiry whether, and if so, how, the mischief resulting from Mr. Telchadder's brief could be redressed. In relation to a breach of a covenant against antisocial behaviour, there is no escape from the conclusion that the inquiry requires a value judgment on the part first of the covenantee and then of the court determining whether the requirement of sections 146 and so on. And then just actually picking it up, because my learned friend, I think, tries to make this case do more work than it really is capable of doing. Just after the reference to the 1925 Act, it says, had Mr. Telchadder not only jumped out at Miss Puncher, but, for example, deliberately perpetrated a significant injury on her, Wickland might well have been entitled to conclude that the breach was irremediable. That there's therefore no need for it to serve notice to remedy. that whole section just underlines the fact that these are matters of evaluation. They are not matters of black letter law, to which there is a right and a wrong answer. And what is then significant, once you've got your head with respect in the place of recognising that what these cases are dealing with is exactly the point in our case, which is to understand within the factual context of a contractual dispute where the discussion is whether or not a particular breach is capable of remedy. It is with that in mind that you then understand, we would submit, the force of the cases on which we rely, Crane and Wittenborg and Force India, which I do not suggest are authority in the sense that they are not cases in which the ratio decides the point that's in front of you. But in a sense, they're better than that. They're more powerful than that for my purposes, because they proceed on the assumption of all parties and highly experienced judges on the assumed basis that repudiation of contract has got nothing to do with answering the question in relation to a contractual provision such as ours as to whether or not a breach is capable of remedy. That's the value of those cases. The very fact that it's assumed without argument that that's right, in our submission, is an extremely powerful point. You've been through those cases, and Melanfriend very fairly took you to the passages on which we would rely. I don't actually think there's any a further advantage in our doing so. So Crane and Wittenborg and Force India are the two that make that very clear assumption. Woodchester and Swain, again, we put it in as an analogy. Again, it's not authority, but it proceeds quite clearly on the basis that a contract which expressly provides that a certain identified breach is repudiatory, nevertheless requires the court to address the statutory question of whether or not it was remediable within the statutory regime. So I agree, it's an analogous. It's not directly in point, and it's not authority in the technical sense of a ratio that decides the point in front of you. But as we submit, it's better than that. It's not quite 15:15, but I was going to start on
a
slightly
different subject.
Yeah.
In which case we'll stop there. Thank you very much, and resume at 10:30 in the morning.
Okay.
All right,